BBC, inspiring Uganda.
Good evening and welcome to Behind the Headlines. My name is Timothy Nyangweso. Tonight we focus on the protection of the Sovereignty Bill 2026 that was passed by Parliament yesterday. 53 entities and individuals showed up to give the public hearing on different aspects of the bill. But the committees, both legal and defense, went to retreat between Friday and Sunday, and a lot happened there. About 35 members of Parliament showed up, discussed the bill. Some agreed, some didn't agree, but we later on saw 6 minority reports being presented and 1 major report. But then the majority won in Parliament and said the bill should go on to be passed. But there are elements of this bill that still hold contention, especially on the area of sovereignty, but also on the area of foreigners, their interests in this country. It has come from both the political, the economy, and now it seems more inclined to politics. Let me get to the panel that is presenting this conversation tonight. On my immediate left, Yvonne Mpambara, a justice lawyer that is with us this evening. Good evening, Yvonne, and it's good to have you.
Good evening, Timothy. It's good to thank you for hosting me, and good evening to our dear viewers.
Next to Yvonne is the Honorable Segona Lubega Medad, representing the people of Busiro East, and also presented a minority report yesterday, is with us this evening. Good evening, sir. And
you did not indicate that I represent them, I think, until next week. Good evening, Timothy, and to my colleagues.
Making his maiden appearance on our show, Mr. Enoch Barata. He's a lawyer, but he's also the Director of Legal Services at the NRM Secretariat. He's here with us. Good evening, Enoch, and it's good to have you.
Good evening, Timothy. Good evening, viewers and my colleagues here in the studio. It's a pleasure being here.
Lastly but not least, the Honorable Lumala Emmanuel Dombo, the Director of Publicity and Information at the NRM Secretariat, is with us this evening. Good evening, Honorable, and it's good to have you.
Timothy, good evening. Good evening, our viewers and my colleagues. It's a pleasure for me to be back again here.
The last time you were here, you promised me that you would be sending some NRM MPs-elect to be on this panel, but it has been difficult to get people to discuss this from the yellow camp there.
Preferably after swearing in, so that they can come in their own right as members of Parliament, other than coming as members of Parliament elect, which shouldn't be. So hopefully after next week, when they have taken their oath, and hopefully when the House is fully constituted, and even better still, when the Parliament has conducted the induction of members of Parliament, and they have been introduced to the rigors of Parliament and what exactly happens, progressively introducing them to come and discuss and take their floor, because now they are going to be our leaders.
Okay, let's jump into it. So you can be part of the show. Go to our YouTube channel, drop your comment there, let us know what you think. X platform there, we're on the space. Drop your comment, we'll be reading them at the top of the hour. For text or WhatsApp, 0709 60 25 92. Let's jump into this conversation. And Yvonne, let me come to you. You presented yesterday, and we'll come to the Honorable Meda to give us context for his minority report, but also what transpired in Munyonyo there. What were you presenting, and what is your contention with this bill?
Oh, I did not present yesterday.
Monday.
Yes, I presented on Monday, but I'd been part of the consultation process since Friday. We felt the bill was an anti-people bill. It was an anti-people people's sovereignty, and it was very important for majority of the public to show up and be part of the legislative process, because it's important for our legislators to also know that we are not satisfied with certain laws, that we are not always bypassers and secondary participants when it comes to legislation. So it was for us to show up and show dissatisfaction with the law, that it had so many contentious issues that were not properly tabled. We feel that it was not a well-drafted law. It's very unfortunate that it has reached a level where it has been passed again without the public being actively part of the amendment process, because you know that some of the sections of the law were amended, but the public is not even aware. We're even trying to get access to the law up to now, and we do not know what was amended. We don't know what's in the amended law. And I think we can, even when we followed the parliamentary process yesterday, the Speaker was also not sure. She kept asking, but I have the original law. What amendments are you talking about? When the law was trying to tell her that, you know, this law was amended, why isn't it withdrawn and reintroduced for the first reading again after the public has been consulted? And she says, no, I have the same law. So we are not sure. Did they table the same old law without the amendments, or have they passed an amended law? So it's for the public to be aware of the kind of laws that Parliament is passing. You know, most times we need to remind our government. It has become a trend for the people to remind the government that they are trustees, that we've invested power into them to represent the people. So when we see them reaching a level where they are defining sovereignty for the people, it becomes very worrisome, because we're worried whether now we are dealing with a complete dictatorial regime that decides that government policy becomes what national interest is. So people were worried. They were worried that right from when the Constitution vests that power into their hands, to vest it into the hands of government as a trustee, it's not doing its role. It's now doing the role in reverse. It's making it seem like it's acting as the people itself, and yet it's not consulting the same people that gave it power. So people are worried about their sovereignty. We are worried that some of the laws that are being introduced are laws to oppress. They're not laws to protect. They're not laws to protect the citizens. They're laws to oppress. So citizens have to show up on a united front and say, we do not want a bad law to be passed. It has become such a current trend now with this government that every single year there are 2 to 3 outrageous laws that they are passing, and the public, I think, is now tired. They're tired of keeping quiet and expecting them to do better, and they're failing at it. So
53 individuals and institutions showed up to share on these public hearings. And one of the things I saw the chairman of the Defense and Internal Affairs Committee, the Honorable Wilson Kajenje, say is that you all made recommendations and recommended that if the amendments are done, the law should go ahead. Is that what really transpired with what you were one of the people that presented?
We told him that the law should pass if they amend it.
Yes.
I mean, I think it's procedure for Parliament that if you've amended the law and there are certain sections that have not yet been presented to the public, you have to withdraw it and represent it back and reintroduce it for the first reading. But they went and did the second and third reading all in one and finished and passed it. And the public up to now is not aware of what exactly was amended. It is through hearsay, it's through the corridors of finding out what exactly was amended. They are supposed to withdraw it and reintroduce it.
Have you been able to see what they passed yesterday?
I've gotten bits of it, and I'm not even sure because it's not through the proper channels of communication from Parliament. We are getting background information through groups that we are in that this is the law that was amended. And then we also question if the Speaker yesterday was asking the leader of opposition that, which new law are you talking about? Because if it's amended, then it's a new law. It has new sections we don't know about. The public does not know what was amended. So even if she wasn't sure herself, how is the public sure that the law that they talked about amending before is what has been amended, that the clauses that suggested should be amended is what was amended? We do not know.
Before I come to Honorable Segona, what do you make of the conduct of Parliament yesterday? What was your reading? Especially LOP came up, the minister came up, there was a back and forth there, 6 minority reports, we'll get to Honorable about that, but also the conduct of the Speaker in the House there. What do you make of it?
This bill has exposed the nature of the legislative process in Uganda. And it's very absurd that we've had to witness the level of unlawlessness that this country has retrogressed to. It's very unfortunate that we have to watch a Speaker who is meant to represent a Parliament and represent a legislative process for the people behaving like this is a house for NRM to pass their interests. What are national interests? Are they interests for the ruling party, or are they interests for the people? We need to understand what these legislative processes look like. So we are confused at exactly what a proper legislative process looks like, because the Speaker no longer respects any form of procedure. She passes things as she wishes. And we think the regime is doing exactly that. They are passing things through procedures we don't understand. If people are insisting, if the leader of opposition is insisting that this is not the proper procedure for passing a new law, why are they insisting on going ahead to pass it? Has it legally been passed? Should we say it has been legally passed?
That's a very interesting question, and I'm glad Enoch is here, so we'll get to that part there. The Honorable Segona, you presented a minority report yesterday, and quite an interesting report you presented. But let's start with, were you in Munyonyo?
Yes, I was.
What transpired there, and also the hearings, were these put into consideration even as you were deliberating in Munyonyo between Friday and Sunday?
Good evening to you again, Timothy, and to our viewers. I applaud my brother Jonathan Adul when he was opening his minority report presentation yesterday. He quoted verbatim. The Catholics here told me that it's not verbatim, it is verbatim. The quote from President Joel Kaguta Museveni Buhabulwa. Depending on the nature of the state in a given society, law can be an instrument of oppression and exploitation, or of social justice and progress. Law is not synonymous with justice. It's not always synonymous with justice. It can be, but it may not be. What is legal is not necessarily what is just. Law can be used by the strong against the weak, by the rich against the poor, by the minority against the majority. Historically, law has been used by the oppressor against the oppressed. During the slave period, enslaved people were owned and disposed of like chattels, and it was perfectly legal to own a slave. The NRM government is strongly opposed to having laws on our statute books which serve the interests of the minority against the majority of our people, or which in any way promote to serve injustice or advance backward interests in our society. Yes, I was in Munyonyo. What transpired? We discussed and shouted. I think to present a graphical picture of what was there, there were contentions, some of which were reproduced in the minority reports that you saw. I didn't want to go into the stories, as the speaker termed them. I decided to go straight to the points. Now, on the one hand, some members felt that the consultations were grossly inadequate, and that the consultations we conducted were cosmetic, did not serve a useful purpose. I want to tell you, first of all, when the Constitution talks about the people, it is not talking about the urban dwellers that people think, oh, they are the most intelligent and that their views represent the entirety of our country. I did pose a question. What happened? Were the people of Chisoro, where my sister here comes from, represented? Did the people of Kitgum present their views? Previously, when we were dealing with legislations that are as important as this one, we would traverse the entire country. I remember we would divide the committee into 4 groups. One would take the northern route, another the eastern route, another one would go to the western route, and another one, probably all of us would traverse areas here in Uganda after or before we scatter to different parts of the country. And that parliament was a very popular parliament that we took to the people. We gave ourselves time. The 45 days rule was still applicable. These days, the government brings the bill and the government wants the bill to pass the following day. We do not get enough or adequate time to consult. The Supreme Court of the land, in what was termed as Malemabilis and others versus Attorney General and I think Attorney General, popularly known as the Mbale case, the Supreme Court guided us that actually from the Constitutional Court to Supreme Court that actually consultation must be meaningful. It is not consulting just for just. It is imperative and is embedded within the Constitution of the Republic of Uganda. So one of the arguments was that we did not do enough consultations. The second is, while we were still there, my brother Joel Museveni, the president, wrote a letter on the blue paper saying, this is not, the bill you're talking about is Rugambo, is Ruwali. This is not the one I initiated. So we started asking the question, where is the one that the president initiated? General Severino Kahinda Otafire from Ruhinda, the purported author and the sponsor of the bill, did not appear, not even once, in the committee to tell us about the bill and to tell us where is the one the president initiated. All those were contentious issues. There are those that were of the opinion that the president should also be requested to interface with the committee, or that we write to the president to tell us what he meant, to give us a copy of the bill he initiated in cabinet. Now, the leadership, as it turned out, of course, you saw the president's letter was saying, I have called the two chairpersons of these committees and directed them. Now listen to the language. And directed them. So we were asking, sir, when you were meeting or talking to the president, were you representing us? Tell us what you discussed with him on behalf of the committee, so that we may know his instructions and directions to you, or maybe to the committee, to the joint committee. We thought that there is legislative independence. But if our leaders are called by telephone and directed on what to do, we get worried. And indeed, because he had directed them, and somebody rose, I don't want to discuss in the videos on them, somebody rose and said, yes, he's the chief executive, he's the chairman of their party. He has all rights and powers to direct them. They forgot the case of Brigadier then, Henry Tumukunde, where the Supreme Court castigated the Speaker of Parliament for not doing his role in protecting parliamentary independence. So after that, obviously, now I've told you the direction that was being taken by the leadership of the Joint Committee, and then some members of the committees, the two committees. So of course the voices went a little loud. Nonetheless, we reached a point of disagreement when a motion was moved to adopt the proposals made by the Honorable Attorney General, Shirya Wachiwanuka, and therefore that we adopt them and do not do the clause by clause analysis. That one we opposed because we were saying, look, we have a duty, we are paid, we are instructed by both law and the voters to scrutinize the bill clause by clause. We lost that, and the motion carried the day. First by voice voting, two by division lobby. So we lost it, and when we lost it, that is the point, because at that point we felt that the majority report has been written. Now, I am not one of those who say or agree that the Honorable Shirya Wachiwanuka, Attorney General, by presenting his second version of his opinion, amended the bill. Technically, he cannot amend a bill that he does not, he did not sponsor. Oh, sorry? That he did not move. Because the author, the mover, is different. However, the Attorney General is a stakeholder, like all others. When he brings his views, we listen. Excuse me. I hope the witchcraft is not coming from NRM.
You have a nice shirt, by the way.
Thank you.
Tending towards yellow.
Not blue. Yes, so we parted ways at that point and decided to do minority reports. Now, even amongst us, there are people who had different reasons. It is allowed, the two lawyers will agree with me, you may say, I agree with Barata J in his reasoning, but for different reasons.
With his conclusion, but...
Yes,
yeah.
I may agree with his conclusions, but my reasons are different. And that's how we parted ways. And within the minority, we also had to write minority reports, you know, by all the individuals that you saw presenting. For example, you saw that I said Honorable Chiriwachwanko could not amend the bill, so it was not an amendment. And indeed, he skillfully put his views of the Honorable Attorney General on the views of the Honorable Attorney General in very small letters, then on the sovereignty protection of sovereignty bill. Now, other people thought that was an amendment, and I said, no, it can't be. Treat them as views. Now, if you want to treat them as views of a stakeholder, and you want to take them, you must also listen to the majority of the stakeholders. In other words, put him on the same scale with the others and listen to them also. That's how we came up with the conclusion that of the 53, only 3 people supported. Actually, the statistics have been improved. 57, only 3. Honorable Chiriwachwanuka, Honorable Yusuf Nsibambi, and a gentleman called Asimwe from Fort Portal. Only those 3 supported the bill. The rest of the stakeholders that we interfaced with, and those that wrote memoranda, rejected the bill. What the biggest and fattest stakeholder that rejected the bill was the president. So that is at the level of facts. But there were also other disagreements on technical grounds. When you looked at the bill introduced a new concept of the sovereignty of government. That is unheard of. It's not in the Constitution. And I'm glad that eventually even the majority conceded on this and said yes. So we protested that. Number 2, we protested the criminalization of enjoyment of civic and political rights. Now, with the president's intervention through that letter that he wrote to us, fellow countrymen, and to this Bazukuru, there are certain things that were dropped. I mean, for me, it was not a fight in vain. To begin with, the law is a bad law.
The most important.
Ill-conceived and cooked to imperfection. However, it was not a fight in vain, and I want to thank Ugandans for demonstrating the need to defend their sovereignty. And indeed, Ugandans, kudos, because you fought for, you defended your sovereignty. Because Ugandans came out and said no on social media and everywhere, because even social media platforms are under attack in this law. You saw the Governor Bank of Uganda. I have seen a promise by the CDF this evening on social media that the views he expressed may cause him problems. Of course, maybe outside the legal framework. But under the law, he is protected. Secondly, he defended the country, by the way, because the mistakes that had been made in this law, in its original form, my God, everybody would pay. Now, with the views from Bank of Uganda, not governor, but from Bank of Uganda, discussed at a technical and board level. Don't forget that the governor is the chairman of the board. Financial Intelligence Authority, religious leaders, cultural institutions that took it up upon themselves to make a contribution to this bill. individuals of goodwill and good standing in this country. You all contributed immensely, and we thank you. Now, with time, they went on, even after telling us that they're adopting the Attorney General's views, and then causing us to disappear to go and write minority reports. They convened and started considering clause by clause, because of course it was embarrassing, even with the proposed amendments by the Attorney General. So the little shine that you see on the report, the Baganda said, "Umkwano guva mungabo." You know that you fight, and after fighting, that's when you become friends. I don't remember fighting with my brother Enoch in '97. He didn't fight me, maybe because he needed my notes, but we became friends. So through that, we came up with what you saw. Now the trouble that remains is here. With the amendments and unintended consequences, we went back to the original bill as conceived by the president, because the president's conception was, I must deal with Vesigi, I must deal with Chagulani. They are getting a lot of money. Now, when he gave the bill to his technocrats and other handlers, for them it was embarrassing to say we are going to write a law that targets individuals. So they tried to quote it by bringing on board other people. And that's how they attracted unintended consequences of saying now, religious freedom is under attack. Freedom of expression is under attack. Political freedoms are under attack. The economy is under attack, and so on and so forth. The Constitution. Because, for example, if you looked at the definition of a foreigner, you see, citizenship is not granted by law. The Constitution only recognized that some of us are citizens by birth and everything. I have no knowledge of anywhere whether my forefathers have ever been anywhere. All those that I know are born here. Then you get to other people who apply for and acquire citizenship by registration, by naturalization, and so on. So that alone was offending Articles 9 through to 15. Then you look at Article 28. The bill was basically criminalizing a number of activities and presuming them illegal. It was presuming that once the money has come from outside, once the money has crossed a certain threshold, once the money is associated with a particular activity, then it is criminal. And it is up to you to go and prove that it is lawful. Then there came this other monster of registration and, permission by the minister. For those of us that, I don't know if I was around, but for those that have been around, we may recall that during Idi Amin's time, you would not freely access foreign exchange. So you would need permission from the minister to use your money, whether you have sold your land or goats, to acquire foreign exchange. Whether you want to go for treatment abroad and so on and so forth, or even to go and do business. I know of a colleague in town who wrote and said his mother went to the Minister of Finance back then for permission to buy foreign exchange, go and treat her husband who was dying of cancer. On 3 occasions, the minister was not in good moods. On the 4th occasion, the secretary said, okay, you try your luck.
Okay.
And the man died because the minister got the papers, the application form, tore it and threw it away. So that's where they were sending us to the minister. You have no recourse to appeal. There is no appellate process. There is no due process. If he says no, either on recommendation of a particular department or on his own is not satisfied, he would not grant you the license. But the worst and laughable thing was when they said if you do anything which is a preserve of government function under the 6th schedule to the Constitution, again you would be against policy, and that would be illegal, that would be criminal. What are those things reserved for government? Health, water, education. Those are functions delineated as against local governments. Then they said, if you go and do that, So these things we've been doing, of buying ambulances, of donating boreholes, fundraising for public schools which are reserved for the government without permission, that would be an offense. So the entire thing was ridiculous. Finally, not to eat time for other people, the contradiction between two provisions in the law. There is a section or a clause that exempts organizations, companies, etc., by whatever name called, if they are established and or regulated under another statute. Now, when you look at all of them, apart from individuals, political parties, NGOs, etc., they are exempt. They are exempted from the application of this law. That, however, is negated by clause 2.2, subclause 2 of the bill, which now fixes it on activities that even if you're a bank which is exempt to the other side, but you engage into activities, and they shamelessly said of a political nature. I think there's a way they coined it. If it is political, then you fall under the act or the bill, and then therefore it would apply to you. I laughed at it. Because you see, the discussion and interpretation of the law, if you engage in political activities in Uganda for or in the interest of a foreigner, I'll come to the interest of the foreigner. Now, here they are saying you fall in this category, you have brought yourself into the application of this law. However, you're exempted. One thing they forgot to do is to subordinate the exemption clause to the application clause. Instead, they used the word for avoidance of doubt. Technically, they could have used the word notwithstanding the provisions of that exemption clause. If you do the following, then you bring yourself. But they did not subordinate that one to this clause.
Thank you.
Therefore, if it is not applicable to me, even when I engage in these activities, the act is simply not applicable to me.
Let me come to you, Enoch. The bill to protect Ugandan sovereignty by regulating foreign influence in governance, politics, elections, public policy, public opinion, national decision-making, and aiming to control persons or organizations acting on behalf of foreign actors to regulate foreign funding linked to influencing activities. The main problem that this bill is addressing, Uganda lacks a specific law to deal with external influence in government policies, development priorities, election, civil society works, digital misinformation. It particularly targets foreign-funded activities that may conflict national interests. Why is this so broad, so ambiguous, that you're saying you want a specific law, and yet this seems to be broader to catch everyone?
Thank you, Timothy, and I'm happy to be here on this show today. I think it's my first time here. Now, I would like to point out, first of all, that there are a lot of hot button statements that are thrown around, very emotionally persuasive, but not backed by fact and not backed by anything really. Now, what you seem to be discussing here, Timothy, is the bill as was first presented before Parliament, and not what was effectively passed into law yesterday. So effectively, what you have just read and the document you are reading from is not the content. It is the bill, all right, that was presented, but the content was adjusted. That's why you hear this confusion about amendments, and I'm glad my land friend, Honorable Segona, has made that point clear from yesterday. So this idea that the law was amended, it is of course a fallacy. It is a lie, in fact, because either people are just confused or they don't read. If you read the report, the majority report, it makes a comment clause by clause. Clause by clause, it makes a comment of what the bill was saying, what they are recommending, and what adjustments they recommend on the basis of the presentations that they received in Parliament. So you can't say that there is nowhere you can find these laws that were passed yesterday. I mean, you honestly can't say that. So there is a clear process. Was there anything wrong with this process? Absolutely not. This is exactly the job of Parliament. The job of Parliament is to go, and when you read the regulations themselves, they tell you, they are in no uncertain terms. Read Rule 132, 134 of the Rules of Parliament, 208, 210. All these are telling you that the committee can propose amendments. Either the committee, the first committee, or even the committee of the full house when they go back to the second reading. They can propose amendments. It is in the rules, it is expected. Because otherwise, what is the legislative process? The legislative process is to create legislation, right? It can also, the committees can also invite any government or public officer. In fact, Rule 2110 talks even about the Attorney General being invited to assist in any business. So the idea that, this whole idea, and that's why I'm saying these are just hot button statements that people make, but the rules are there, and unless people are saying that they don't read these rules, and which is mostly what has been happening. So there was no amended bill. There were amendments proposed as a result, amendments proposed as a result of the committee work, both at the committee stage and at the next committee of the whole house, which is at the second reading. So I would very much prefer to discuss what was passed yesterday rather than that which was initially presented, because what has been clearly agreed, and from the very beginning, I recall that even at the time of the first reading, I wrote an article in the New Vision. The Land Attorney General wrote an article in the New Vision. Both of those articles, even at that stage, acknowledged that some changes can and probably ought to be made to the text of the bill. That has not been in dispute at any one time. The disappointing thing I have found for me is that you are talking about 53 presentations or 53 memoranda. Only a handful of those actually went or bothered to quote the provision, point out what the problem with the provision was, make a recommendation on how they saw that provision. The first people to do that were the Uganda Bankers Association. They were the first people to take that approach, and I liked it 100%. Everybody else, they were just copying from the same script and, making very generalized statements about how this is bad and this is that, and very few of those, and I have read quite a number of those presentations, all 53 of them. Very few of them made recommendations. My land sister here, I think her presentation was entirely just being this bill. I don't recall a recommendation from a presentation. But that's beside. That is a recommendation. Well, because that is a misunderstanding, and that is a misunderstanding. That is where the misunderstanding of the process, of the legislative process, comes in. It doesn't. The rules say that Parliament can make adjustments as long as they do not go outside the objectives for which the bill was presented. So they can make adjustments. So it is not that every time there's a small change, you throw out the bill. In fact, even the rules provide on who can withdraw the bill. Only the person presenting it can withdraw it. What I'm trying to point at here is that there has been a systematic, nuanced misrepresentation of the bill and of the legislative process. And I'm happy that my land friend, Honorable Meda Segona, has really been there. He has put his foot down and said, no, I am not participating in this one. This is the correct process and this is how it went. So the bill is there. Now you talk about other legislation. Let me first point out just one other point here. The exempted, and you must read very carefully again, the exempted are supervised institutions or other regulated institutions established by Act of Parliament. And that's a completely different thing from saying you operate under another Act of Parliament, established by an Act of Parliament. So the law is very clear, and if only people cared to read themselves without hearing too much, because there's a lot of misleading noise also. And I think that is what the president was referring to, and now people are saying he rejected the bill. He did not reject the bill at any one point. He simply says, I just hear a lot of noise about things that are actually not in the bill. The bill people are making noise about is not the bill that I know, because the bill that I know talks about X, Y, Z. That is what the president is saying. So there has been a lot of noise, but thankfully, I am glad, as my land friend Honorable Segona said, I am very glad that our legislative process proved its worth. I am very glad that our democracy stood the test. And this is exactly what the debate is supposed to be about. This is exactly what the consultation is supposed to be about. As I have said, for me, I think the consultation was quite sufficient, because if you look at 53 and you have only about 5 people actually paying attention to the bill and making recommendations to it, including the Attorney General, that's why that debate of there were 53 and only 3, you just read those papers and you will find that all of them, in fact, there are several that are copied from exactly the same text. And I have read them. I know their source. And exactly the same text, exactly the same conclusion.
Very specific so about the broadening of this.
What you have read, Timothy, what you have read, Timothy, is the objective.
And I'm asking,
right?
Because
now, after the objective, read the law, because that objective there is not the law.
The law is here. Because what I'm asking
that objective, Timothy,
is how broad it is.
That's a statement of what the objective is. So the narrowness of the statement is to be found in the clauses, in the actual text. And where they were overbroad, they were refined. That was the import of the propositions, which were passed, by the way, by the members of the committees. Where they were wide, and that is where you have these exemptions coming in, where you have criminalization of foreign interference. They have added intent to be clear, because in law, it was in the presented bill, it was presented as a strict liability offense. Now it is not a strict liability offense. You have to prove intention, etc. In my view, those were always clear, but since it created a lot of noise, no harm in clarifying them, because even the word sabotage itself, it exists on our law books, and it is very clear that you need to have some intention. So all those were narrowed down. The definition of foreigner, which I think was the one that created the most noise, was also refined to make it clear. But I also wanted to say that even before it was made clear, a foreigner, that definition of somebody a foreigner, even then did not take away citizenship. And even then. But nonetheless, point was made, and we made that point even at the earliest, just hold on, even at the earliest, we made the point and said, okay, this one should be indeed adjusted, and it was adjusted. So when you look at these provisions, at the end of the day, the process has produced a law that meets the objective and that is good for the country. And for me, I congratulate the members of parliament, all of them. I congratulate the citizens, including everybody who went and made presentations to the committees of parliament, because that is what the process requires, and so the process really worked.
My last question to you before I get to the Honorable Dombo. What threat are you protecting? What is this threat? Because
you see, that is a very
foreign influence, that is of foreigners. What is the real threat here? Let's articulate it well.
First of all, that is a very misleading question, because you want to pinpoint a specific threat.
Okay, what threat?
And say this happened, and say this happened, and therefore this is what happened. Foreign influence is not new. In 1938, when America first legislated on its Foreign Agents Registration Act, what was the issue? The issue was there was a lobbying company. It was actually a communications agency, so to speak. But while it was doing genuine business as a communications agency, in fact, it was discovered it was promoting propaganda on behalf of an enemy. That is, there were about two events then. So that is just an example of foreign policy. In Australia, we have had, for example, there was a case, and that has nothing to do with their law, but just an example of what influence can be. A partner in a large firm, in a large tax firm, who had access to tax proposals or economic proposals of the government before they could be effected, was secretly leaking them. And in 1 year alone, the economy of Australia lost 26%. Revenue of 26%.
Examples that are relevant to us here. You're telling us about the US.
Yes, I am, because you seem to be confused. You seem to be confused about what constitutes foreign influence.
No, it's not the confusion on we're on a threat. What threats really have this come to solve? Because
the threats are very clear. The threats are that there is increased propensity for foreign agents to influence internal political activity.
So we're insulating ourselves against...
So we are insulating ourselves against that foreign interference. And I think even today the president made another statement and said, and gave an example of how Obote was removed. It was a case of foreign interference. So these are threats that exist, except now the threats then used to be perhaps more direct. Now they are more refined. They come clothed in genuine activity, while in the background they are executing other activities. So that's where the financing argument comes in, and so on and so forth.
Honorable Dombo, and Honorable Medad Segona made reference to it, you know, the consultations, even when you were in Parliament there, 45 days there. Why was this bill such a rush? What was the urgency?
First of all, allow me to congratulate the members of Parliament, because they performed tremendously well. Because I was in that house for 20 years. And we had situations where a bill was moved in one day and approved and passed.
You're proud.
In as much as it doesn't breach the rules of procedure, there is a reason why the rules of procedure were made in such a way that even the committee stage can be skipped and the House,
There is a reason why you are not
the whole House
saying
is,
you're proud.
the whole House can be transformed into a committee stage. So this has happened before, and to me, this is the second time I'm coming here to talk about briefly this sovereignty bill. To be honest, I'd never heard about it until we appeared in the NRM caucus when it was first introduced the members of the NRM caucus by the Minister of State, Honorable Muhozi. And he clearly defined what the issues were, including what threats may be. But when the bill came to the House, I was perplexed because the debate was centering on issues that were never the focus of the bill. I personally got confused. This situation was made worse by the members of the Ugandan Law Society, who at one time issued an ultimatum to the members of parliament on TV that we are going to name and shame the members of parliament who are going to support this bill. I was left perplexed and wondering, because the Constitution gives the mandate to make laws to the members of parliament. Now, as a professional body of lawyers who are more conversant and more informed, I had expected them, which they later did, because I later saw a memorandum which they submitted. But at that time, I even sent on X and what did I say? These professional lawyers, they should be assisting members of parliament to highlight the deficiencies within the proposed law and also propose areas that should be remedied. And to this, I must compliment Honorable Segona. I was on TV following his submissions and arguments to the Attorney General, and I left the screens a more informed person because of his arguments. And I believe this law was very much improved because of the likes of Segona being very articulate, but also being resilient to stay in. Because I've been many times offended by members of the opposition at times, when they choose the quicker options of boycotting, and then you leave either uninformed people to make decisions when two heads together, they should have helped to make a better law. And to me, when the Uganda Bankers Association came up to make a presentation and raised the challenges of reporting and to say the Bankers Association, their decisions are under the Bank of Uganda to try different law. Now, when you subject them to seek authorization from the Minister of Internal Affairs, do you introduce a parallel legislation? And how does it affect the other institutions with whom you collaborate? These were valid questions which were raised by a professional association. And I was interested in hearing what the Attorney General or the Minister for Internal Affairs was responding. The issues about the foreigner and arguing about the young girls and boys who are in the foreign countries trying to labor, they have supported our budget here to the tune of 2.5 billion, the economy. $2.5 billion coming in. And people are saying that this law, once passed, is going to declare these young people to be foreigners. I said, but how? Is there anything I didn't understand when the presentation was made? But the bill, as now the Act of Parliament, as has been passed by members of Parliament, it's because the process has been followed, the process has been sufficient. If the framers of the rules and the law envisage to say that the number of people who are for and against the bill, if that was the basis for decision, they should have said so. But whoever was against the bill either made propositions for amendment or says that the law under its current proposition offends a number of things, including religious institutions, And right now, when you look at the exemptions that you are made, when you look at the powers which the minister had thought in the proposition of the law, which were denied by the outcome of the law which has been passed, and when you look at the definition of the foreigner and the other improvements within the law, you can see that the members of parliament, irrespective of the speed you are blaming them to have passed the bill, did a better job and a tremendous job that has been done.
Honorable, there is a thin line there, because at what point does it come from civic education to influencing the public to oppose government policy?
You know,
because we are having a discourse here, all of us here. If this law comes through, can't it cherry pick whoever here to go and be culpable?
That clear that that law was passed.
No, it has
That bill
has not been assented
but
to
it
and
was
gazetted.
passed. But it was passed.
So no. If
Parliament
assuming
so-
somebody
Gazetted by
signs
the
tomorrow and it is gazetted tomorrow, for now they may not.
But it was passed. For now, it is
Yeah, yeah.
passed. So that word is clear. And it has changed from that. And
No,
this is what I'm
suppose-
emphasizing, because I would
The-
like
but
to know.
The man has not signed it, so it's not law.
Gentlemen,
Still stands.
I want to stay with Honorable Dombo. At what point does it come from civic education to influencing public policy that opposes government policies? Because we're here discussing...
But which of the two should be criminal anyway?
And that's where I want to put it to Honorable Dombo. And Eno can come into support. But this is a conversation about...
Waranyangweso, let me tell you, the proposers of this law have got access to the intelligence information which we don't have, because this is the Minister of Security or Minister for Internal Affairs who is working together with the government, that is facilitated by Parliament to do intelligence gathering. That has been keeping this sovereignty and peace in this country over a period of time, and they know the rigors through which they have been going. I don't think the minister will come and do all that briefing to you in either the committee. Perhaps he did it in cabinet. He could have done it in cabinet, because when you look at the nature of cabinet, that is a secluded place, and they take an oath that whatever they discuss there, it binds them by collective responsibility, but also it cannot be diverged to the public unless authorized by whichever authorization. So there are reasons.
I'm glad you have spoken about intelligence, because there were intelligence reports, I don't know if it's last year, about wrong intelligence being given, and hence some people's lives were taken. So when you say that, what I'm trying to help the public understand is the broadening of these things, where you call them political activities, where you're naming interests of a foreigner. How do you substantiate an interest? How do I know Honorable Dombo's interest to come to this show?
It can only be done through investigation. I want to give you an example. When the Americans wanted to arrest bin Laden in Pakistan, they went through an agency of the United Nations and sponsored an immunization program in the Pakistan. They were trying to get the DNA of the children who had been born in order to trace the DNA of bin Laden. That was a specific activity by an agency of the United Nations, but specifically provided with the resources in order to conduct an investigation. You just cannot be sure to what extent the people who want to interfere with the processes that we're doing, how far they can go. Recently, the president told us when we met him in Rakula, Mr. Barata was there, I believe, when one of the priests in Uganda, when the bishop, actually the president reported that one of the bishops from Masaka, I think, had approached the president of Uganda to plead for a priest who had been arrested, and the president said, we can, but they must volunteer information. Where did the money come from, and what was it intended to do? These are areas of influence, and it was reported in the papers, and that subject matter was live on TV, including UBC. So there have been
Do you
areas.
also know that there are live criminal proceedings in that matter? when that your discussion on that is sub judice, as you normally remind.
Yes, I do. I do, but they can be contended with the various
that priest is not here to defend himself.
Okay, we can leave that one, but let me interject here slightly. You see, the idea here, Timothy and colleagues, is that Uganda and the citizens of Uganda determine their destiny. They determine how they are led, they determine their policy, they determine their legislation. The moment a foreign interest comes in, the moment a foreign interest comes in, it cannot be assumed on the face of it to be in the interests of Ugandans. At the very start, it is a foreign interest. At the very start. That is why,
how do you determine a foreign interest?
It is a foreign interest.
How do you determine it? Because I can honestly say America has given us $2.1 million to the Ministry of Health.
Just wait. And you see, the problem is you do not follow through in these questions you ask. If America has given you $1.7 billion for Ministry of Health, how did it give it? It was a transparent negotiation with government. It said, we will give you this in exchange for this. The law simply requires people register and disclose. It does not say stop. It says register and disclose. It is about transparency. So if you have gone through a transparent process, then you have no problem. So when you give an example, that is then you miss the point. The example, for that example, it explains the whole point actually. That was a transparent process. You said, I am going to give you this money to put in your health sector. And this is what I expect of you. And I have the transparency and say, oh, this is this man's interest. So if I am going to give him this in exchange, does that serve the interests of our people? Does that serve the interests of Uganda? If yes, we go ahead. If not, then I have the right of refusal. That is what the law is about.
There must be an agreement.
That is what the law is about. It says you register and disclose. Once you register and disclose, then we are able to see, and this is where the answer to your question is, then we are able to see, is this in our interest? Is this foreign intervention in our interest? Or is it entirely a foreign interest against our interest? Then the determination can be made. So you cannot predetermine at the moment. It is a fact-based case by case.
Okay.
Yeah.
Let's take a quick break and come back to dig further into this bill and understand even its implications once it's ascended to by the president. What does that mean for you and I? What does that mean for civil society? How far can we get involved in political activities? This and more after this break.
And that's it for today. Till the next episode.
Like a daily bando, like a daily bando, like a daily bando. Omuliro nguwulira muli mu mutima kukankana like drums. Kalakata, kalakata, endungu ya kusabula. Mikono juu, free of fire, free of fire, free of fire.
It's back, bigger and with more business opportunities. It's the Pearl of Africa Tourism Expo Poate 2026, Uganda's flagship tourism event. Poate 2026 will take place from the 21st to the 23rd of May 2026 at the Speak Resort Convention Center, Munyonyo, under the theme Wanderlust. It's your time to thrive. Yes, it's your time to tap into Uganda's renewed optimism and tourism growth. Tourism stakeholders, travel trade partners, and tourism enthusiasts will be part of the Poate 2026. Come and network with like-minded people and unlock new business opportunities. To participate, register at www.poate.co.ug. Poate 2026 is brought to you by Uganda Tourism Board and partners.
The government's core mandate is to maintain law and order, safeguard citizens' rights, and provide essential public services.
Remember, one of the pillars of a roadmap is innovation and entrepreneurship.
There has been this question of how are you protecting our indigenous seed?
It's going to be a tall project. That answers somebody's question.
The Front Bench has brought you insightful discussions on governance, security, healthcare, justice, and commerce.
Why do you go through this complicated procedure, involve the lawyers? You bring the case against him, the judge will hear you out and pass judgment, and you're out of court in record time.
We remain committed to keeping you informed and engaged on key national matters.
So these are huge, these are powerful organizations which now Uganda chairs. Why don't you come together?
If we haven't migrated to the e-card because of various reasons, including that not all the people of Uganda have smartphones.
You can sit in your house, apply for a passport.
If you have a Ugandan who has a successful logistics firm in the US, it means he can come to Uganda and do a lot more.
Every Monday at 8:30 p.m. with me, Jethro Kasaiji, your interface with the government only on your public broadcaster, UBC, Inspiring Uganda.
Welcome back from that quick commercial break here on Behind the Headlines. Even when we're not here, the conversation is still ongoing. But perspective is being got here and there. But let me read some of the messages. Before I do that, let me remind you of our panelists that are with me in the studio. Yvonne Mpambara, social justice lawyer here. Honorable Lubega Medad Segona, representing the people of Busiro East. Enoch Barata, Director Legal Services at NRM. The Honorable Dombo Lumala, who is the Director of Publicity and Information at NRM there. I told you I is Dombo, then Lumala. We shall get that one will be for the next show. Good evening, Timothy. Thank you for the show. Some of the clauses within this bill that was passed yesterday are still contentious. They are too broad for us to understand, especially how do you determine interest and intent. Those are areas that I'm still scrutinizing here. This is James from Kitugum. Thank you, James. Good evening, Timothy. This is Teacher Asimwe in Mbara. This law is in bad faith. The spirit behind it is bad. Government is trying to cling on to power, protect itself from its citizens, and moving forward. Okay. Good evening, Timothy. This is Anne in Kabela Maido. She says, Timothy, thank you for the show. I do not understand some of the clauses that are there. How do you say you're doing it in favor for the Ugandans, yet the people who gave you the mandate in trust, you are violating exactly what they're discussing? I also don't agree with Enoch when he says that Ugandans are being protected. It is not Ugandans. It is the government protecting itself against Ugandans. Very interesting submissions here. Keep your messages coming, 0709 60 2592 there for text or WhatsApp, but also our X platform. Get there, drop your comment. We'll get to it at the top of the hour, and our YouTube channel. Yvonne, you had some, when I read the messages, they're really mixed messages on how Ugandans really perceive what was passed yesterday. Because there are three different sets of documentation here. How would a layman understand what this document is saying?
Thank you for starting with that question. And I think this is a debate we are having here. The public, you've seen the back and forth we are having right here. So if we are land friends on this panel and we are trying to understand, and that same confusion, you may agree, but the public, you've had the questions, right? You've had the questions from the public. Let's not assume for the public. Citizens have a right to ask you because they don't understand. So
maybe they understand, but they have a right.
Yes, they also have a right to ask you questions.
To put us to test.
Absolutely.
Exactly. So
but their asking does not make the answer wrong. They can ask and ask and ask.
We've not yet reached the answer.
And the answer will remain right.
But yes. Enoch, we've not yet reached there. Let's go step by step.
You can see the quarrel at the bar.
Let's go step by step. We need to understand what exactly was passed. Understand to the layman. Leave us here who are land. Explain to the ordinary Ugandan what exactly it is that Parliament passed yesterday. Explain it in very simple terms on how they can understand it.
Because I don't want to go through. Time? What was passed is bad law.
It's bad, exactly. And this is what they are trying to tell you.
You the answer.
And it's what we're also trying to tell you, that what you've passed is a very horrible law. But you don't want to take it because, as usual, NRM likes confusing people. You've taken us around in circles. You were asked very clear questions. Enoch, you asked very clear questions on what exactly are the threats and why is the law so broad and vague? And you did not answer them. Why?
I have told you the law is not overbroad and vague. The bill, as originally presented, had parts which were overbroad and vague and subject to multiple interpretations.
Okay.
When it went through the committee made proposals to amend those provisions in line with the rules of procedure of Parliament. The law was subsequently passed. What are the threats? As I have told you, the threats are not predetermined. That is why you have a law. The threats are determined fact on a case-by-case basis. Okay. And that is why the principal provision, the principal requirement under this law is transparency. Register and disclose. As simple as that. Now, when you divert yourself and you start arguing NRM, this, that, you are going to go into areas. If you're asking about the law, ask about the law. The law is saying if you fit this categorization, register and disclose, then we shall be sure that what you are doing is within the national interest. If you're talking about national interest, look at Article 8A of the Constitution. It tells you what that national interest is. Okay. So let us read it. It does.
Can't you allow me to finish?
I've read it. I know the amendment introduced by Right Honourable Mama Babazi. It only said that for whatever we do, we shall do in national interest.
And it does not. It says what the national interest is. You read it.
Please go on.
Anyway, so the people are asking you, because they're also trying to understand where this point of sovereignty that has slowly shifted from the constitutional definition of sovereignty being in the people has shifted into sovereignty of the government. Because government, for some strange reason, is now trying to introduce policy in government, and they're trying to make it seem like this is where sovereignty is best rather than the people. And I think this is why there's so much confusion. So when people are calling for the withdrawal of the bill, who is the government and Parliament answering to, especially now that they've passed the bill? People showed up in large numbers and said, this is bad law, withdraw it and bin it. So whose interests is the Parliament working in if they are passing a law that citizens have insisted they don't need, they don't want, and that is not necessary? Whose interests are they serving? Have we changed the constitutional mandate of government serving the people to people serving the government, or government is serving itself? Because if people have called you to withdraw the bill and bin it, why has it been passed? This is why they are confused. They turned up in large numbers and gave you all the different reasons why this is bad law, and you still passed it. And you're continuing to tell them you are serving their interests by passing a law that is protecting their sovereignty. Which protection is there if they've told you it's not attacking their sovereignty? And recently, I think it was Lord Mayor Elias Lukwago, when he stated during, I think, one of the presentations during the committee sittings, and he said There are so many domestic attacks on people's sovereignty that this bill does not cater to. Why hasn't it catered to them? Why are we only looking at foreign influence or interference that has not been defined in any criminal offense law and has been reintroduced by a random law and just placed there as an offense, and we've not defined it? Why are we bringing in something outside, yet we fail to cater to domestically what is hindering people's sovereignty? It's very important to answer those questions, and I'm glad they kept saying, you're introducing this law for the people. Which people have asked you for it? You tell us, are you serving yourselves or you're serving the people? The people turned up in large numbers and refused the law. So who are you serving? Are those their interests?
Yvonne, are there any threats that in this law insulate the people and the country against foreign influence?
When I was listening to my two colleagues from NRM speaking, a lot of it sounds like speculation, and it sounds like a paranoid government.
What is your assessment? What is your assessment? Never mind.
My assessment is you're speculating, because
never mind.
Which foreign interference have we seen? We've not seen it.
Okay.
We've not seen it.
So there are no threats.
It's them who are telling you they've done investigations, they have reports. Have you seen any of those reports?
So there are no threats according to you?
They are legislating in anticipation.
They are speculating.
No, in haste and
They are
paranoia.
speculating and passing laws through paranoia because they are trying to protect their interests to maintain power. They've decided to speculate and pass laws based on speculation.
Yvonne, is there anything good about this law, in your perspective?
In my perspective, no. Withdraw it and bin it. It's a bad law.
And if it could be amended to anything to suit the people of Uganda, is there anything substantial?
Even talking about amendments, you see, he referred to...
It is incurable.
It's incurable, but he was referring to the American FARA law, which we know very well, by the way. And trust me, this law you've introduced is very far from it, because the American foreign agent law is very constitutional. This one has abused over 5 clauses, over 5 articles in the Constitution. The American one you're referring to compare it to this one, you're lying. Because if you go side by side of that law and this sovereignty law you've passed, they are 2 different documents completely. This one, maybe you can refer it to Russia, where they are completely, I don't even want to attack Russia because what Uganda has passed is something else, and even them, they are telling you. If you've been following social media trends, they are telling you Uganda passes exceptionally bad law that is chasing away who? Any foreigner. Those are the headlines on media. I don't want to lie to you. I don't want to lie to you. When you're speaking to your investors out there, they are not going to sit down and scrutinize your laws and sections. They don't. They see headlines. They see headlines from Bloomberg and they are done.
The ones I have dealt with actually read the laws.
I just wanted my sister. She's a land friend. And me, one of the things I like about these land friends, especially the likes of Honorable Segona, is that they usually take the bulls by either the horns.
Mostly. The other one is dangerous.
You can't even do it.
Because to me, I enjoy the jurisprudence which comes out whenever there is a litigation process that enables the land people. Recently, the Constitutional Court annulled a law that was passed by the Parliament of Uganda. Because, 1, it did not follow the procedure. 2, it breached the aspects of the Constitution. So, the law has been passed. We're waiting for the President to ascend. Once he has done that, let the lawyers put it to test. Because we have a Constitutional Court. Finally, there is this provision of the UPDF Act. When you look at the role of the UPDF, when you read the Constitution of Uganda, Article 209, it says to preserve and defend, to protect sovereignty and the territorial integrity of Uganda. This sovereignty, even when it belongs to the people are sovereign. But once the people have made decisions and have a government, the Constitution here gives the power to defend the sovereignty of Uganda to the UPDF, which is part of the executive of government. So when government does this, people are not, this argument of saying it is now the government becoming sovereign Government is just fulfilling the constitutional mandate.
No,
as
no, no,
provided
Honorable
for under the law.
Dombo, Honorable Dombo, you started a little bit well when you said the duty. There is a duty. We conferred a duty, call it even a function, to protect our sovereignty. But the argument we are putting in this is that the government was taking away our sovereignty. When you opened the object and you would find that there are two sovereignties, so to say, provided for in the bill. I liked the idea that actually we moved away from that when government conceded. There was sovereignty of the people, then sovereignty of the government. They are two different things. What the UPDF is required to do under Article 209, because I have tested it, even against litigation in the Kabazuguka case. So I have a photographic memory of the provision. What they are supposed to do is to protect that sovereignty, but not to change the sovereignty and own it.
Exactly.
But for me, I will come to the bill for colleagues who have been saying, oh, it's a good law, and I can show you, or demonstrate to you. I don't know if Yvonne is
let me come to you. Yvonne, if the president assents to it, it's gazetted, what implications do you foresee? Civil society, political activities, what do you foresee in there?
I think for the start, let's acknowledge the fact that we don't feel that much has been adopted from what the original bill was displaying. We don't feel much has been adopted to reflect a much better law. It's not a better law at all. I think they amended, okay, you said it's not an amendment, but you adopted a couple of additions that were, I think, proposed a couple of additions around the definition of a foreigner, and I think they changed a bit of the minister's power from defining that who exactly is a foreigner and remove that power from him. There were just a handful of them, but it's literally still the same law. And I think that's why it was very important for our colleagues from the government to properly explain what it is they've passed. What it is they've passed, so that people understand.
You're putting a very onerous job on them to explain it, because they actually don't know it.
They do not, I agree entirely. They do not know it. So originally, most of what citizens tabled is still at threat. And it's why we're even discussing here when they were saying there are exemptions in this law. When you go down to scrutinize, there's no exemption at all.
Yeah, I wish you could
There's no
show me this,
exemption.
because
We are all still targets, because you do not, we don't know how an entrenched government is going to wake up and get annoyed at Timothy today for speaking about a certain land policy, and before you know it, you are a target. You can't be sure. One, that's how vague it is. In its definitions, it is vague.
I wish you could point us there.
So we can't be sure it's targeting. We can't be sure who exactly has been exempted, because even when I was scrutinizing it to look at, say, academia and researcher that had said had been exempted, they only discussed the ones that are registered. But do you realize there are so many foreign fellowships that are happening between Uganda and other countries also doing foreign fellowships here in this country that are not registered as an academic institution?
So they should register them.
So,
Okay. Let me come to Honorable Seguna. You raised something that was quite interesting during your presentation of the Minority Report, especially on the registration of an agent of a foreigner and the scope of what they are capable of doing. You almost said they are giving them legal mandate to continue indulging.
No, because in principle, at face value, the law is intended to diminish influence of foreigners. Let me state first of all that is it that every foreign policy is bad? No. You see, the example given by Enoch Barata of the American law in 1938, it was specifically to deal with enemies of the state. And the concept of enemies of the state or enemies of the king is not new, because it is part of the law we received from England. There are people referred to as enemies of the king, enemies of the queen, enemies of the country. I think in 2021, during the campaigns, there was a feeling that probably Kyagulanyi was getting some money. Was it 2000? Yes, that he was getting some money from Rwanda or something what the minister did was to go and amend the regulation, the schedule, and declare Rwanda a hostile state. Do you remember that?
Yes.
I don't know whether they have since removed Rwanda from the list of hostile states and therefore enemies of the state. So America was specifically dealing with its enemy, and they named their enemy. Now, in our case, we are assuming that every foreign policy or influence is bad until and unless it is approved by cabinet. So I did ask a question. Does registration make what is unlawful lawful? That you see, it becomes lawful per se. It becomes our interest per se. Or that every issue, foreign issue that we conceive, we run to cabinet, to consult cabinet and ask, is this now okay? Or we go to the minister and say, is this now okay? I was going to demonstrate to you the contradictions, intra and inter-contradictions within this act, or the vagueness for which it will equal to void. The doctrine in law is void for vagueness. And that is a test, a constitutional test, against which a statute is judged and therefore may be declared null and void. Look at the definition of agent of a foreigner in the interpretation clause 1. An agent of a foreigner means a person who engages in any of the activities referred to in section 2. As an agent in section 2I, that is, as an agent, representative, employee of a foreigner. Now tell me what you find offensive in that, other than the description of agent of a foreigner being derogatory. How do you tell me that by working with a foreigner, or doing business with a foreigner, or being a representative of a foreigner, therefore, I should be subjected to that derogatory description? On works on orders, requests, supervision, or under the derogatory? The description that I'm an agent of a foreigner, you know? And I'm going to juxtapose it against the substantive clause. Then you listen and decide. While being financed or subsidized by a foreigner. Now that is the definition of an agent of a foreigner. Let's go to the substantive clause and listen to this. Clause 25, reporting of foreign funding. Now, by substituting for subclause 1 the following: a supervised institution shall not pay out any money to an agent of a foreigner without the agent of a foreigner submitting proof of declaration, that is B, of the fund. Now, the supervised institution you're talking about, for example, is a bank. Okay? When does the bank get to know that I am an agent of a foreigner within the meaning of clause 1? What is it that I'm supposed to present there? Supposing for me, in my dealings, I insist I'm not an agent of a foreigner. Isn't that going to hamper with transactions? 2, they even go ahead to criminalize a supervised institution that contravenes this section 1, subsection 1, commits an offense and is liable on conviction to a fine not exceeding 200,000 currency points. Now, you see how you're going to stampede these institutions. You see how you're going to hamper transactions. And you wait when the law comes up. I'll now respond broadly to what Enoch Barata says in the clauses. I told you that actually the best would be to be bold, shameless, and say, we're not talking about foreigners. We are talking about enemies of Uganda. In which case, using what they are calling their intelligence, they would have a schedule. The minister would be given powers to amend the schedule, declare, because now that one is an executive function, to know who our enemies are. If I'm dealing with a foreigner in the country X, and that country is an enemy of the state declare that this one is an enemy of the state. I remember in 2015 or thereabout, when we launched FOC, Peter Nyombi, the late Attorney General, was very quick to go and amend some schedule to name FOC a terrorist organization. When we were doing peaceful demonstration, walk to work, walk from your home to work, don't beat anyone, don't insult anyone, the government was very quick to declare FOC. We moved from FOC because it was a terrorist organization. Imagine we were declared a terrorist organization. Then the next thing, and we asked Peter Nyombi, so tell me, who are the members of this terrorist organization you have named? The same members metamorphosed into 4GC, For God and My Country. He was very quick to go again and amend the schedule. It is clear, with all its problems and constitution as it was easy for a citizen to know, what is it that I'm prohibited from doing? Who is that I'm prohibited from transacting or associating with, because this one is a terrorist? When you require Ugandan to know foreign policy so as not to report it, you are not defining that foreign policy, because you can't define foreign policy of every nation X, Y, and Z. Then you go to the broad, imprecise, vague, and void statements that are put in here. Look at disruptive activities. Look at foreign policy. How do I know? Because even Ugandan policy is not codified anywhere. Then you go to where I act to influence, or I influence somebody to influence government policy. All you're doing is to arm the police and enforcement agencies to simply grab Timothy, just put a statement in the charge sheet and say that this one was involved in disruptive activities, because all the activities that have been listed and of course adopted in the majority report here are activities that already have precise definitions and prohibitions in existing statutes. If you're talking about the security of the country, there are offenses within the Penal Code. There are offenses within the Anti-Terrorism Act. There are offenses within the Anti-Money Laundering Act, and so on and so forth. That's why we were saying, before you even look at the text, the draftsmanship, etc. of this bill, go to existing law. Laws exist that you do not even require this one. Now, the activities that are proscribed, political. No, we even have the Electoral Commission. The Electoral Commission law, because they are talking about electoral offenses. The Electoral Commission Act, the Presidential Elections Act, the Parliamentary Elections Act. You're talking about unlawful assembly. That is already catered for in the Penal Code. Very elaborate. Now, when you charge me under this one the way it is imprecise, it is arbitrary, because even what amounts to an unlawful assembly is not mentioned here. Yet in the Penal Code, it is provided for the process of declaring an assembly unlawful is already provided for. So I think this thing of chest thumping to say, Muzei does not lose, Muzei Tebuhabua, he cannot be corrected, is what is killing this country. And the problem is not my brother, the president. The problem are these people. I will not point at Dombo, because he knows very little about what we are talking about. Talk about Enoch Barata. One, who had the benefit of sitting in law class with me. Two, who had the benefit of reading my notes. Three, who has had the benefit of interacting with me for the last 25 years. We have had pending coffee for a very long time. Probably, he would have asked me these questions. Okay? And we're not doing this because we hate the state, because we hate government, because we participate in crime or cross-border crime. We are saying this because we love Uganda more. That's why we want to stop these people from proceeding to break the constitution. How do you proscribe assembly? I mean, how do you proscribe contributing to the development of policy? Because the moment I say what you do not want to hear, the next thing is to declare me an agent of a foreigner. I'll give you 2 examples as I close on this. In 2008, I was a deputy minister for information in the Kingdom of Uganda. And there was a proposal to amend the Land Act. We opposed it. I spoke against it as a spokesperson of an institution. And we gave our proposals to government in writing to a committee of parliament. General Museveni was somewhere in Wakiso Gombe and said, those people who are opposed to the Land Amendment Act are going to realize that they are playing with fire. That very evening, they started looking for me. The following morning, they abducted me. For the next couple of days, weeks, I was missing. Simply because I made a comment on, that was unpopular as far as the president was concerned. And I was locked up, including in the bush. I am on court bail for the last 17 years. The second is when the Honorable, I think when we all commented in disapproval of PDM, and we gave our reasons. And the president said we are enemies of the state for opposing PDM. But now, I pay taxes. I am telling you that through PDM, you are squandering my money. It is ill-conceived. It is simply political. You may be right. I may be wrong. I may be right. You may be wrong. How do you proscribe my contribution to policy development? All that a mischievous police officer will need to do is to add just one ingredient, that the points I am making are sponsored by a foreigner. Just look at my brother, my son now, Genome Hall's tweet against the Governor Bank of Uganda. That the Governor Bank of Uganda appeared before a committee of parliament. He made contributions that even the president has agreed with, because when he met a section of people in his caucus, he told them, no, this is wrong. So he agreed with the Governor Bank of Uganda. We benefited from the technical input of the person that manages our purse, the person that runs our economy, the person that was telling us the impact of the bill on the economy of the country. But now you see, somebody perceives him wrong. The next thing is the comment, you pay for this sin. Just imagine if we had this acrimonious law in place already. You would have the Governor Bank of Uganda locked up. Probably you will have the entire board and management of Bank of Uganda locked up. For doing what? Contributing. And you know this is not new. When General Tinyefunza Munungu Bwajojo David, in 1997, we were in our first year, appeared before a committee of parliament. He was being asked to comment on the war in northern Uganda because he had been a commander there. He made his comments, which he might have been wrong, factually. I want to believe he was right because he had been there. He made his comments. The next thing was a threat to court-martial him. That's how he ended up in the Constitutional Court. So this business of threatening to gag people that dissent is not new in our country. It has been here. So I am telling you that the law is a bad one, both in spirit and text. For the text, I have demonstrated and given you some causes. By the way, I had intended to benefit my brother Enoch Barata. When you read clause 2 itself, that's why I talked of the inter and intra contradictions. In clause 2, they are saying that is for avoidance of doubt. This act applies to an agent of a foreigner who engages in any of the following activities through any means, including the use of digital platforms. 2, and I read a portion of them, the most ridiculous, engage in political activities to further the interests of a foreigner, solicit, collect, disburse, it is for purposes of influencing or sponsoring political activities to further the interest of a foreigner, to represent the interests of a foreigner, recruit, etc. They use the word for avoidance of doubt. But now listen to clause 2 to C, immediately following B. It reads, and I quote, for avoidance of doubt, and notwithstanding the provisions of this section, this act shall not apply to monies or funding received from a foreigner by a supervised institution. Notwithstanding this section, including 2.2,
Yes.
which is the application clause. And this is where I told you that people make mistakes, but we are advised when your enemy is making a mistake, you do not interfere. In fact, you proceed to facilitate the mistake and confusion. So already, 2.2c has subordinated to the preceding one, which is intended to apply and to bring all these ones. So the first defense is embedded within C. When I was exchanging my views with the...
That's the first defense is embedded in C.
Yes.
Absolutely correct.
So when I was exchanging...
I'm trying to follow where the problem is there.
No, where the problem is that it actually makes this law impotent.
But then you are saying it's a bad law.
Yes.
You are saying it is going to be used to curtail people.
You see,
and they have made clear exceptions, and you are saying there were no exceptions.
No, I didn't say that. But by the way, I did not say that.
Yes.
I've been consistent.
Yes.
From the day I read the majority report, because it was uploaded on Monday at 4 p.m. And remember, I was required to write and submit my minority report at the earliest before plenary sitting on Tuesday. So I had to submit this. I submitted my report, my response by 11 o'clock yesterday. Ugandans don't know how much we sweat to generate what we present. And even as I leave Parliament, I urge Ugandans to respect their leaders or their MPs. Because some of them, yes, there are those that may cheat along the way by not doing their work. But now the point I am making and why I'm telling Barata it's bad law, you don't waste Ugandan taxpayers' money to generate a law which I've said is impotent.
Which one is that, 224? 224C?
224. 224C.
Yes.
Yes, because 224C is now a superior clause to 224B.
Which exempts certain people.
He knows the rules of statutory interpretation, that a latter clause supersedes the former. But even by way of interpretation, specific interpretation here, 2.2b is subordinate to 2.2c because it says notwithstanding B or the preceding or any this section. Now when you say these ones, and I want to respond to what he said, that you talk about supervised. Yes, I will read it for him. A supervised institution or a person or institution regulated by a regulatory body. Why is, you know, they were talking about the political parties, where I told them, you've given the old man hot air. A regulatory body under an act of parliament. These political parties are regulated by the Electoral Commission under the Political Parties and Organizations Act.
Correct.
you have already exempted them. You have exempted health or medical facilities, academic or research institutions, a person for commercial, domestic or family use, faith-based organizations. Who are you left with?
Everybody who is not there.
Who is not there?
Everybody who is not in that category. Everybody who is not. You see, you can't argue it this way and then the other way. I think what we are saying has been very, very consistent. There was, in certain clauses, overbreadth, which now these exemptions are saying that these entities here are already subject to another regime. And that's what the argument has been actually all along, that there is all these other regimes, FIA, PPOA, and so on and so forth. So what the law is saying, yeah, what the committees of parliament eventually did and the full house of parliament, it said, yeah, that makes sense if for those ones that are already falling in another regulatory regime, in other words, they already have registration and disclosure requirements, then you will be dealt with under those.
So tell me one
regulations.
Tell me those that
for
are
those,
not.
For an individual, for
those
instance, an individual myself. Yes.
Okay.
So I am captured. If I am not doing anything for academic, medical, academic research, etc., I'm captured.
No, if you are not a political party.
I think you and the Attorney General communicate.
If you are not, how about NGOs?
Or if I am not,
how about NGOs?
There are those NGOs that may not be. They are, by the way, they are bodies that are not registered.
Like.
There are bodies, she just mentioned herself, there are bodies which are not registered. And that's the whole point. Bring yourself into one of those regimes. Bring yourself into any one of those regimes. Bring yourself under the FIA.
How am I not registered again?
Not yourself, not yourself. You are getting it wrong.
Enoch, let me put a question to you.
Yes.
And there's been a back and forth here, but let me put a blunt question. Is there anything that can be improved in this bill, in your view? Because
Timothy, let me put it to you like this. I can answer your question.
There has been improvement, and also I agree with the transparency.
Yes.
I also agree with the threats.
Yes.
Is there anything else we can improve to this bill to improve its spirit?
Timothy, a bill was presented to Parliament.
No, this is for debate purposes.
And this is exactly what I'm answering. A bill was presented to the committee. This very question was asked. Is there anything that can be improved? Yes. It was improved by the Committee of Parliament, by the Committee of the whole House. It was passed. So that was improved, that was passed. And you have seen, and you can go through. Unfortunately, when we are in between a debate of legal provisions in a strictly legal and technical sense, and then mixing it with generalizations, a lot gets lost in between. But maybe maybe somebody should actually write an excursus on this, and then we can debate that. But yes, those improvements were made, and the bill was passed into law, subject to completion of the rest of the processes that will require it to now be enforceable.
You're not responding to the question.
I have responded to the question.
You're responding to the question.
I have responded. No, you are asking me the question in the past, and I am telling you the bill was passed into law with improvements, with adjustments.
So there is nothing to improve about this bill?
But there is nothing. What can you improve? The bill has been passed into law. You wait for it now. If once it is enacted and it is signed and it becomes law, you are saying, can it be amended?
Timothy,
maybe.
Yes. Whatever we are discussing now about this bill is basically speculation.
Yes.
We are dealing with speculation. Let's pray that the president assents to the bill and the bill is put to test. One, we shall test whether what the fears of Honorable Segona and his friends will come to fruition, and that will happen. Then the second test will be the litigants who may choose to say this bill has offended the provisions of the Constitution and interferes with the liberties of the population. Let us take it to the courts of law. Those are the two things that can be done. When it is implemented, it is now easier to look at the implementation and see, we wish you had done better here. Then it can be a subject for improvement through an amendment.
Let me stay with you, Enoch, especially on this bill. If, when the president assents to it and becomes an act and it's gazetted, do you have concerns, especially in its implementation? The Ministry of Internal Affairs, the implementing bodies, their interpretation of what the law is, their interpretation of the letters here. Are there concerns that you see in implementation that could vulgarize this bill?
Okay. So, again, Timothy, thank you very much for this question. And let me emphasize that what we have now is a Protection of Sovereignty Act that awaits the other processes, gazettement and forwarding to the president for assent. Are there concerns? No. I do not see any concerns whatsoever. Why? There are a multitude of laws. This is not the first law that is going to fall under the auspices of the Ministry of Internal Affairs. There are several laws that fall under the Ministry of Internal Affairs. There are several laws that fall under the Minister of Security. There are several laws that fall under the Minister of Defense and all other ministries in that line. So what you are saying is you are speculating, and this is where the argument gets derailed, is the speculation that there is a potential for abuse. The potential for abuse of anything at all exists every day in every aspect. That does not stop you from working. The potential that the human resource policy at UBC will be abused does not prevent you from coming to work every morning. So that is not a concern to me. If that ever happened, there are avenues to address it. And those avenues have been there all the time.
My last question.
There are sufficient structures, sufficient safeguards to address any potential abuses. So for me, there is no concern at all.
There is something that Honorable Segona raised about the process of appeal. Looks like the buck stops with the minister.
No, first of all, my land friend will agree. Every decision of a public official, whatever they might be, is subject to judicial review. Automatically. It doesn't have to be provided in any law. It doesn't have to be written there. It is automatically subject to judicial review, and that's just one remedy. Then all the other remedies exist. And that is how the example Honorable Segona has just given, that is how laws get struck out. You see people appeal, go here, go there, and the law gets struck out, and these are not, those incidences have been several, and adjustments are made.
Thank you. Let me come.
But sorry, Timothy, yes. Isn't that one of the concerns people had raised, that this particular bill has no sunset clause? They had raised that issue. They said Parliament does not have a review mechanism for us to come back to and say that it can review what this law has been, because the bill does, okay, now it's a law. The law does not explicitly point it out. It has not been assented to, exactly. So I'm hearing Enoch and I'm wondering,
but does Parliament review, does Parliament usually reserve itself powers to review acts?
But almost every law, no, this is the thing, and you've been talking about it. No.
Now, in some countries, they
I think we are talking about different things.
Some countries have got a post-legislative scrutiny mechanism.
Some countries, but we are talking about Uganda, my friend.
Post-legislative scrutiny mechanisms I mean, are available naturally, and they have committees that do it. I think Honorable Dombo remembers in the 9th Parliament we wanted to introduce a committee,
but it didn't.
But it didn't work through. Yeah, but I think Timothy, the issue that Enoch raises is very fundamental. You see, in law, the grounds for judicial review are different from appeal. The grounds for judicial review are technical. They relate to, one, that the minister acted without jurisdiction. Two, that the minister exercised the jurisdiction wrongly. I mean, their grounds, they are listed. What we are talking about here is that there is no appellate process. Because he may simply say, and within the law, because the law gave him the mandate. But the law did not provide where he is wrong in law, in his interpretation of the law. Because that one is not a ground for judicial review. That one would be a ground for appeal. Now, appeal by its nature, and Enoch knows, and this is where I disagree with him. He said, I will agree. No, I will not agree. Appeal.
No, you will agree that judicial review is available.
Is a appeal, but the grounds may not be available.
But judicial review is available.
Yes, appeal is a creature of statute. If the enabling statute is not enabling you to appeal, you cannot appeal. Where the minister exercises his powers under this clause 18, and he refuses either on recommendation of the department, or in his opinion, you do not merit, you will not appeal. And that one is a ground that offends the Constitution by denying access to judicial remedies. When you asked Enoch areas of improvement, and probably this is where we may also all have erred, I think I must say. Why? Because we had said it's a bad law. Probably would have provided a mechanism for appeal in this.
A person aggrieved by the decision of the minister may apply to court of competent jurisdiction for legal redress in accordance with the applicable law.
No. That's not appeal.
That is 18.
Yes, that's not appeal. You're talking about legal redress.
Gentlemen, allow me end with the
you know when you start splitting hairs, then you have a problem.
No, that's
you are saying there is no remedy
No,
to
I didn't say that.
challenge.
No. I said there is no right of appeal.
But here, there's a right given to
Now you have limited the remedies.
Okay. Honorable Dombo, especially the relationship between the legislature and the executive, the letter that came from the president, him summoning the chairman there, you know, him
summoning the chairman.
At what point do we have a relationship that is just a handshake and we're not going to the elbow? Because the relationship seems to be becoming quicksand to the leaning of the executive.
We have always talked about separation of powers of these various arms of government, but to what extent do you hold that possible? Because you have a legislation that has been, when you look at the rules of procedure of Parliament, there is a reason why the bills from government are given express provision for them to be expedited over the private members' bills. One, because the affairs of running the government, I mean the country, are in the hands of the executive, which is privy to some of the information that we may not be having. For instance, when they brought up this bill, like I said, there is some information which government will know through cabinet or through the various forms of intelligentsia, which is not going to be prescribed or submitted in here. So in our relationship, you can have Parliament having, through the caucuses of Parliament, because you have a president who is the chairman of the party and also a member of the caucus that is in government. In such a situation, you will not see the separation as usually people tend to suggest that there is going to be a separation of powers and then the president will not know. In situations of governance where he too has received the mandate from the population through a general vote. So there will be interaction, there will be constructive engagement, and at times it may be misconstrued. But this engagement is not intended to subvert the Constitution, but it's supposed to improve the governance like it has always done.
Thank you. Let me read some feedback before I give you parting shots. This comes in from Prosi Ngulu, says, this is basically the control of civic space, of individuals and political space, okay?
That's what governments do.
There's a regulation.
Ruth in Wakiso
not
sends a message and
regulation.
says, good evening, Timothy. Thank you for that eminent panel, and thank you for avoiding the noise and the chaff to get to the substance. But the substance seems like it's targeting a few people. This bill has been weaponized against politics, okay? This is Flavia. She says, good evening, Timothy. Thank you for the show. I appreciate all the submissions there, especially the ones from Honorable Segona. It is a balanced conversation, but I still feel this thing is skewed towards the benefit of government. Okay, let's leave it at that. I'll give Yvonne, Honorable Segona, Enoch, and finally Honorable Dombo, your 2 minutes of your parting shot.
2 minutes. Well, I'm going to be honest. The first time I read the bill in its original form, I genuinely believe the drafters wanted to overthrow the president and the government. That is the first thing that came into my mind. I said, are these people against the president? Are they trying to overthrow him? What exactly are they passing? Because when you start to criminalize international support, when you start to criminalize investment, when you start to criminalize international solidarity, what exactly are you doing? Us saying that when we criminalize foreigners as if the majority of what they've been doing for this country is bad, I don't know what image we're trying to portray. Majority of Ugandans depend so much on foreign aid, government programs as well. So when I was reading certain proposals from, say, the Attorney General, from Enoch, my brother here, he also put out a very long article, I think some time back in the newspapers. And I just looked at it and said, this is so disingenuous, because how are you not seeing the consequences of what a bad law like this can do for this country? We're already grappling with poverty, honestly. Most of Ugandans are employed under the civil society spaces. You have like a 20–30% of Ugandans who are employed under it, and you're deciding that these are people whose livelihoods you're going to cut short simply because a government is paranoid. So we need to be genuine about the consequences of this law. We need to explain to the people that this government has come to serve itself, and that the sovereignty they are talking about is not structured under Article 1 of the Constitution. Because if that were so, whatever they are defining as a national interest, whatever they are defining as foreign interference, it would have a very clear picture. And I think what we've discussed here is there's no one who is sure what exactly this law is trying to address. We need to be honest about that. So we need to retract it, and I'm very sure if the president is not being self-centered, he's not going to assent to this law. And I think that's a question that Enoch should have answered when you asked him that, are you sure there's nothing to improve about this law? Because then what happens when the president refuses to assent, saying there are so many things to amend from it? What happens? He would have stood here on this platform and been a very dishonest person.
Yeah, you sure?
Because he should know. He should know.
Thank you.
So let's be honest with people.
Honorable Segona, your parting shot.
Yes, sir. Well, to my brother Joel, just refuse to assent to this bill. No, Joel Museveni. Refuse to assent to this bill. That's number one. Number two, while I refuse to name call colleagues because of decency, I want to call upon all Ugandans to know that this is our country, and that we can do better than this, and that we have sufficient laws in place to ensure accountability, transparency, public interest, and let us listen to the views of everybody. Yesterday I told Parliament that Uganda is not firefighting. The country is here, and we're all here to stay until we go naturally, and we shall leave people in our shoes. That even as we are living, we in Parliament now, there will be another Parliament of able, competent men and women to make the laws, even when we do not rush. For the benefit of those who say they are not able to understand what we are talking about here, because this is a report where we are saying insert this before this and so on, that they will not understand, the technical team at Parliament will organize this into a properly prepared text. That will be the Act of Parliament, which the President may assent, and I have advised him not to. And if he assents to it, it will be clear. With life granted by God the most gracious, we shall come back and show you where the problems are. I hope Enoch Barata will still be around and available, and that he will not be arrested and detained under this law as a foreign agent. We will be able to remind him that, look, this and this and that went wrong. Finally, I want to wish everyone a good life. I'm sure this is the last show I'm attending as the MP from Cyril County East on this television. I live with a heart full of gratitude to Ugandans that have supported me along the way, colleagues that I have worked with at Parliament for 15 years, the Speaker of Parliament or the different speakers, those that are alive. We lost one, the Honorable, Right Honorable Jacob Olanya. I've worked with 3 speakers and 3 deputies, colleagues at Parliament in the various committees where I've been. I want to thank you. The people of Cyril County East, I want to thank you heartily and immensely for supporting me for 15 years in Parliament.
Thank you.
I live with a heart that is clear to everyone. Thank you also for retiring me at this age when I'm still able to fight for myself. I shall continue in the political space and support everybody that needs my support. To Enoch Barata, the tea that we have promised each other for so long, and of course for you to benefit from my wisdom that I've collected over the last 15 years. Who knows, I might even persuade you to leave that side where you are and we do things better. Timothy, thank you, and everyone, and our viewers out there.
Thank you very much. Enoch.
Thank you, Timothy. Let me begin by comforting my brother Segona to see from Honorable Dombo that at least UBC will not throw you out like the people of Usero did.
You have become the spokesperson for UBC now.
At least judging from Honorable Dombo. About this very important conversation, again, I am glad that we have been able to have this discussion in public, very involved, very revitalized. It speaks to the democratic credentials of Uganda that have been built over the last 4 decades. The law is here. The law has told you that if you are dissatisfied with the minister's decision, where the minister has been left with those powers, you can apply to a competent court of jurisdiction, and that's very important because it has also left the jurisdiction very wide in terms of which court you prefer to go to. So the law is here, the country is ours, the sovereignty indeed is ours as Ugandans. What the law is doing is saying, let us protect it because we are vulnerable, because of the state in which we are as a country, economically, socially. Even when you look at the period of independence that we have lived as a country, we are vulnerable. And so we are saying, let us put into place certain measures to protect ourselves. And as the President put it, even when we make mistakes, allow us to make mistakes internally and do not impose your own mistakes on us. So let us be positive looking. I think we have, in the last 4 decades, shown that all these fears are unfounded. I have no doubt that going forward, the Uganda will be stronger and stronger under the movement government.
Thank you. Lastly, Honorable Dombo.
Timothy, this is most likely the last show that we are appearing with Honorable Segona as a member of parliament, like he said. I want to give him assurance that this side, outside parliament, there is life also. And he could learn from us who came earlier, about 10 years ago. But like I did mention in the program, that Seguna is a brilliant person whose ideas have improved the course of debate and the ideas that are exchanged. Let this discourse continue outside parliament. There is a tendency in the politics of Uganda, especially by the new young people coming up, of resenting one another, besmirching whatever contribution other people make, and using the media in a derogatory manner in order to offend others. Yet, each of us, none of us is very perfect. We progressively just improve what happens every day. The final one, that let us continue talking even when you're outside parliament, so that we can improve the governance of this country. On Tuesday next week, His Excellency Yoweri Kaguta Museveni will be sworn in. And we have placed announcements in the media. We have invited the party leaders. And I was extending an invitation to Honorable Segona. I'll be sending you a card.
Are you the inviter?
Yes, in the part I am. I'll be inviting you so that you come and join us. We celebrate together because this country belongs to all of us. You know that outside parliament, even when you are still in parliament, we have talked about many things that unite us as a people. Let's continue talking about those things for the best of this country.
Thank you very much. I want to thank you who has been watching the show up to this hour. And I also want to thank the production team for making today possible, for everyone that has sent through a message. Too many messages, we couldn't read all of them. We also want to send apologies. Honorable Tony Oduru could not show up today because of one reason or another, but the gentleman... Jonathan Oduru, sorry, could not show up today. Gentlemen and lady, thank you so much for coming. Are you extending an invite to Yvonne too?
I was wondering.
Maybe I
thought you already had one.
I also think it would have been an overkill of lawyers if Oduru had come here.
Anyway, I want to thank you for watching. Gentlemen, thank you for coming. Yvonne, thank you so much for coming. We appreciate it. And as Honorable Domba said, the 12th, which is Tuesday next week, the president will be inaugurated at Kololo, and we'll be showing you that the whole day. But we'll end with this quote. Every closed eye is not sleeping, and not every open eye is seeing. Good morning.
UBC, inspiring Uganda.
Forex trade mentorship emphasizes discipline, risk management, and emotional control.
Overtrading can be termed in two ways, in losing side and then in profit side.
Often highlighting that success comes from process-driven, consistent action rather than chasing profits. Benon and Osman are mentors at Forex Bulls Academy, and for over the years have mentored more than 1,000 traders across the region.
Okay, now when it comes to trading, psychology is more of mindset, behavior, and character. Yeah, it's how you think before a trade.
Through disciplines, trading is the way to go.
Mufere. Information is everywhere. You can learn how to drive a car on YouTube, but hit the road, things are different.
Very many people come with emotions. The moment they make their first, $100, that excitement goes off the roof. And that's where overconfidence kicks in.
This week we'll learn a little bit more about Forex. In a nation hungry for truth, a world where every story matters, there exists a beacon of trust and reliability. For decades, they've been our voice and our window to the world, holding the mirror of our history. With 4 TV stations and 11 radio channels spanning 27 languages, they stand as guardians of information, defenders of truth. With Mascari Heritage Advantage, they uphold every citizen's right to reliable and free information. Their archived stories shaped our past and illuminate our present. Yet now, as new challenges arise and the world evolves, their mission faces its greatest test yet. Be part of our journey and let's navigate the unknown, uncover the untold, and safeguard our future together. Tune into your public broadcaster, for it is the intersection of trust and truth. Because to UBC, your story, every story, and every voice matters. UBC, inspiring Uganda.
UBC, inspiring Uganda.
Between majority opinion in quite a number of European countries and the attitudes of their leaders. In other words, the staunch support for Ukraine, including more aggressive, belligerent statements by its president, are usually supported by EU leaders and in particular by the EU Commission President, but I doubt that in most EU countries the majorities of their populations would take a similar view. Most Europeans are skeptical of the war and continuing support for Ukraine, and just as they are unhappy about other international conflicts. Put succinctly, I think the European populations, at least their majorities, are much less belligerent than their leaders.
And Zelensky has tried to pin the blame on Moscow for violating his own ceasefire while Ukraine has been launching on Russia. Why would Kiev ignore Zelensky's ceasefire?
Well, I don't quite understand the question really, and I'm not following the military events on the ground quite as closely, so I'm afraid I'll have to pass on that question.
Unfortunately, we don't really understand that logic too, because Zelensky announced a ceasefire for 2 days, and then several minutes after that, Ukraine started launching attacks on Russian civilian objects. Gunnar Beck, former lawmaker in the European Parliament, please stay with us, don't go away, because I have another topic that I want to discuss with you really shortly.
Yeah, thanks.
Now, as Europe prepares to give 90 billion euros to Ukraine, a big portion of those funds might just end up lining the pockets of